Mills. I'm a trustee of the College of Law Practice Management. On behalf of the college, welcome to our discussion of dispute resolution in the times of pandemic and technology change. This is one of an occasional series of public discussions created by the college. I will introduce our panelists and then hand off quickly to our moderator, Jordan Furlong, so we can get going. Jordan, whom many of you know, is among the most creative and influential communicators on legal services today. About practice, regulation, education, ethics. His eloquent and often provocative writing and speaking are essential to all of us who pay attention to this field. You can find Jordan online at law21.ca. Nicole Nehama Auerbach starts revolutions when she isn't championing clients in a courtroom or a conference room. She co-founded two truly innovative law firms. I hesitate to use the word firm, though, because the models are so different from the traditional. Perhaps they should be called law somethings. You can find Nicole online at elevatenextlaw.com. Sohail Mohammed is a pioneering lawyer and judge across many dimensions, and today is leading the way for technology advancement throughout the New Jersey courts. And finally, Darren Thompson, who is a lawyer, teacher, technologist, podcaster, access to justice advocate, and co-builder of the most successful public ODR system in North America, the British Columbia Civil Resolution Tribunal. I only add the North America qualification because I don't know much about what's going on in Asia. So we have four extraordinary panelists to talk about these issues, and I'll turn it over now to Jordan. Thanks, Jordan.
Thank you, Mike, very much. And good morning or good afternoon or good evening, depending on where this finds you today. Thank you all for coming and joining us for this conversation this afternoon. As we all know, it has been a remarkable few months in the justice system and in the legal industry generally. And we have been coping with a tsunami of change in so many areas. And for the people here today who know this especially well, on the front lines of the justice system, in courts, in courtrooms, in litigation, in really the administration of justice, I guess you could say, across the board. And what we have gone through in these last few months, switching from an entirely virtually in-person justice system into something brand new for most of us. It has been online, it's been remote, it's been virtual. And I think it's fair to say that everything considered, it's gone reasonably well. I mean, having had no advance warning that this was coming our way, I think we've adjusted reasonably well, and that as a triage exercise, where we've gotten ourselves to today is not that bad. But now we have to take stock and think about where are we going next and what are we going to do next. And to do this, we're going to really explore two questions broadly over the course of today's conversation. The first of these is what we're experiencing now, is this substantially the way things are going to be now? Is this, to overuse the cliche one more time, the new normal? Or are we likely to find ourselves snapping back when this is all over to something very similar to what we entered in the first place? And I guess the second question, regardless of how we answer the first, is really, with regard to what we have accomplished so far, what has worked well and what do we need to do better? Where are the opportunities for us to improve? And we are fortunate today to have not just three really insightful, remarkable speakers with us, but to have three different and valuable perspectives on the justice system. Judge Mohammed, of course, from the bench, Nicole from the position of an experienced, respected trial lawyer, and Darren as a real pioneer and innovator in the whole area of dispute resolution. So to get us kicked off, I'd like to start with Judge Mohammed, if I may. And Judge, you've already had some experiences dealing with virtual and online hearings and so forth. I'm interested in what has been your take so far? What have you seen? What are your takeaways in this new world we've entered into? And what do you think should be our vision or our direction for the future?
Jordan, it's a very interesting time that we're all living in. And when we look back, I mean, we're already in New Jersey in phase 2, which means limited entry back into the physical courtrooms. But the last 3 months have been a ride of a lifetime. And I say it's a ride of a lifetime is when our Chief Justice announced on March 16th that March 12th, that we are going to go virtual. It was literally just what our President a long time ago, President Kennedy said that we will be on the moon. We will be landing a man on the moon. Americans will be on the moon. But it took us years to get on the moon. But with our Chief Justice, when he said this, we had, Jordan, less than 24 hours to get ready, get set, put our jumpsuit on, which is our robes on, and be ready for this virtual proceedings. And I am happy to report to you, in just 1 week, over 95% of our judiciary staff, including the judges and staff, were ready to offer virtual emergent proceedings. And today I'm happy to report, Jordan, that we have concluded in 3 months 35,000 virtual events, and over 350,000 participants have attended. That is remarkable. But how did that happen? And we all have to give credit to the legal minds. We as lawyers have been trained to handle problems. And this is what we do at best. And the way it started out in New Jersey was first training our judges, because if judges are trained, if judges are welcoming, if judges are going to embrace, that is going to translate the confidence in the system. So I started with the judges, trained all our judges, our law clerk, our secretarial staff, our support staff, then the entire state bar association. And when the Bar Association first learned about this one, obviously courts without lawyers are not going to function. So the Bar Association embraces technology through training, and what we saw was a tremendous embracement of this technology, to a point where we are saying that this new norm is going to be our new norm. There are going to be proceedings that we will continue to have virtually, because, as you can see, if I want to share you very quickly, I will share you one piece of thing that I have a report here. And let me just see here, share, and here we go. Now, this is what I have on the slide that I presented to our judges the other day, about a week ago. And this is a example, remote proceeding in 2015, where I was appearing from my basement, same place I am now, but everyone else was in the courtroom, including my sheriff officer. We have transformed this now to the right slide, where you see in the middle, where you have one counsel in the courtroom getting on the phone to get another counsel in. I have my court staff and other attorneys. Now, you see next slide over, we are, instead of a individual coming in and asking a sheriff officer, where is Judge Mohammed's courtroom? Well, there is nobody there in the physical courtroom. So we have a layout. What I have done is I have prepared a layout where you have a breakout room. Attorneys in a physical courtroom don't have a separate room to talk to their clients, each one with their name. Every morning I get up, before the virtual session is done, I have 8 rooms that I assign breakout rooms, with an assistant prosecutor's name and a conference room, my secretary's room. And these are virtual rooms where people can have private conversation. That doesn't exist in the real world. Now, going back to this one, now there is a gentleman here just this past Monday. If you can see on the right-hand side where he appears, there is a car on the jack. He is a mechanic. He's working for a dealership. When I indicated to him, just sir, your case is not going to be heard for at least another half hour or so, because we're waiting for a report. What did this gentleman do? He went back on the work, and he's working on a car. And then you see the next slide, you will see on the next slide, he has his participant, his boss is also looking at it and saying, wow, that is amazing. Now, this is the reality, because folks who did not have to take a day off, they don't need to. They can move on with their lives, and they can still appear in court while not losing a day's work. So that is what the reality is. And with that one, I'm going to stop sharing and switch it back to you, Jordan.
Judge Mohammed, that is a fabulous illustration. I love that picture, and I love that idea that we don't, again, one of the advantages that we have with this new system is that we don't have to accept as the default setting all of the disruptions that we have always assumed were just part of the way we work in the justice system. Everybody has to stop what they're doing. Everybody has to go to the courtroom. You have to make appointments and get people to cover for you at work or watch the kids or what have you. And I think it's a really good point that we often talk about what are we losing with in-person justice. And there's no question that there are a lot of losses and there are a lot of downsides, but I think it's a really good illustration of the fact that there are advantages and benefits that we never saw coming, and that we can I think, exploit for that reason. And that's a good place for us to kind of segue and switch, Nicole, over to you, because from the trial lawyer's perspective, of course, you see this right in the trenches, in the business end of the conduct of litigation and trials and so forth. And I'm really interested in what has been your experience to date with regard to virtual trials and such, and hearings. What's worked well, what can we do better, and where do you feel we're going in this whole area?
Yeah, well, first of all, that was fascinating because as a trial lawyer, to hear what the judge has to say and the judge's perspective is always just a huge benefit. And so I'm going to be calling you Judge Mohammed and asking him what you think about this or that. It's kind of is, this really new terrain that there's so many positives that you've pointed out, Jordan, already. The amount of time that I spent in courtrooms just waiting through a long call for my case to be called, and you don't want to be late, that you have to usually bill your client for that, or it's your own time. The travel, because I have a national practice, and a lot of judges did not like for out of town lawyers to take advantage of being on the phone, and it's a very impersonal way, and I wouldn't want to represent my clients in that manner if I didn't have to. So all of those things will be saved. I think, the fact that there's the ability to have these breakout rooms, as the judge was describing, is huge, because to be kind of all looking at the same time and not be able to discuss things with your client is a huge disadvantage. However, I think that there's a number of things that are lost as a result of that. And I'm hoping that as we go further into this, because I do think some of this is going to absolutely remain, I think technology will get better. People will get more adept to doing hearings and trials online. But these are some of the things that I worry about as a trial lawyer. Particularly if I have a jury, but sometimes even just to see what my opposing counsel is doing or what their client's reactions are, is some of that is missed online. The interpersonal sort of, emotional, the EQ of you're losing this juror, or, you can tell that you just hit a sore spot with your opposing counsel, depending on the view or what is being portrayed on the screen. You may not see the judge's reaction, you may not see your opposing counsel's reaction, you may not see your client's reaction. And those things worry me a little bit, because I do think that they're important when it comes to advocacy. From just a practical standpoint, when you're dealing in complex matters, and particularly you have a lengthy hearing and an argument, perhaps an appellate argument, I'm used to having everything at my fingertips in hard copy, old school for sure, but you don't want to be caught offhand, right? And so the question is, now if you're doing everything online, are you printing at home every potential case that you might need? Are you printing every pleading? And if you're not, then are you adept enough to be pulling what you need electronically? I think it's going to take some getting used to. Certainly you can get used to that, but I think it takes some getting used to. And then there's the more sort of tangential effects that I don't know that we've measured or we'll see. Things like, there's a large understanding that court watchers are not getting access, or the public is not getting access to all of the type of hearings that they used to be able to have access to by simply just walking through the halls of a courthouse and sitting in. And why is that important? They note things like, what is the bail? What is the race? What is the gender of the defendant in criminal cases? And research shows that sometimes just their presence will have an impact on the type of advocacy and the type of justice. And I think that's very important. So we need to figure that out. And then just from a personal standpoint, I lived and grew up and learned from sitting in the courtroom. When I was a law student, I was lucky enough to be close enough to the federal courthouse in Chicago, and I would spend afternoons watching trials and watching different styles and how did things work. And same as a younger associate, to sit through a lengthy call gives you a lot of information. Number one, how do other people practice? But also, is the judge annoyed today? And should I maybe take some cues from that and act a little bit differently? Or, you know, what's the temperament? And so those sort of tangential, you know, not yet measured things, I think will be really important for us to keep an eye on as we go forward.
Nicole, there are so many great points in there. And the one that I really want to seize upon is your observation about the adjustment period that we're all having to go through. And it's really difficult. I mean, need not rehearse again all the ways in which lawyers are resistant to change and averse to we like things the way they are. I'm going to really briefly share a story I once heard about there was a major trial, and there was tons and tons of materials, and so much so that all the binders required like several bookcases to be brought into the courtroom and placed behind the counsel table for the trial to take place. But at the same time, they had also digitized all of the files and put it on, you know, forgive me, this is like, you know, CD-ROMs and stuff like that. This is how long ago this was. But the interesting thing, and this was the story that the judge who was presiding over this told me, it was the lawyers who had insisted that the bound volumes of everything be placed behind them in all these binders. And so the first time that an exhibit was called upon in the trial, the lawyer began to turn around to get the binder, but at that moment, it flashed on his screen in front of him, right? The actual document he's looking for, and he pauses for a second, and then turns back to the screen and never turned around again to go to the binders. And I think that's the power in a lot of ways of having this technology and everything at your fingertips and able to move quickly. And it's also, I think, an illustration of what happens when lawyers give themselves a chance, just try it once, and you never know what's going to happen after that. Right. I do want to jump on this idea of digitization a little bit, because Darren, this actually brings us over to your specialty area as well, because we hear a lot about digitization of law and this whole transformational process we're going through. But I also think we tend to throw these words around a little bit without as much maybe accuracy as we could. Can you tell us a little bit, what's your view on digitization of the legal process as part of this transformation? And again, sharing with us some of your experiences at the CRT.
Sure, thanks, Jordan. A lot of the work I do is in an area people call online dispute resolution, or ODR. And within that, there are kind of two mental models or conceptual models that you can use to categorize ODR. So one is digitization, or sometimes also called automation. And that I kind of separate, in my mind anyways, I separate that from transformation and innovation. If we're applying technology to an existing process, that is often trying to create a digital version of something that was born in the analog world, for me, that's more in the realm of automation and digitization. At the other end of the spectrum, transformation and innovation, well, this is where you create something new. So this could be using an expert system to provide expert guidance to people, or creating the new, entirely new front end for your dispute resolution process. This is where you use new processes and often technology, again, to create new value that didn't exist before in the digital world. Now, there's no real dichotomy for me. These are just mental models or conceptual models. Sometimes these things would come down to a matter of perspective, whether or not something counts as transformative or innovative. I'm not as interested in the semantics as I am in results. So both of these models, I think, though, are important right now. Obviously, we need to get to the point where we can at least restore some access where our justice processes have shut down because of the pandemic. And digitization and automation can help a lot here. But what I think, what I'd ask people to think about is that whether or not we can do more, whether or not we can also look at transforming and using technology to create this new value and support new processes. For courts and for lawyers as well, I'd ask you to look out for opportunities to leapfrog. So what I mean by leapfrogging here is taking the opportunity to skip an evolutionary step. So the best example for me of this is all of the developing countries who never had to install the infrastructure for landlines for their telephones. They went straight to wireless telephones. See if there's any of these opportunities arising based on what we're all dealing with right now in our justice systems. It might seem hard to leapfrog if you're dwelling on the current process. And I know as lawyers and judges, we're supposed to focus on process. We absolutely do need fair processes. We need just processes. I'm not challenging that. But I am challenging the idea that we can't change our processes or create new processes that still get us to our desired outcomes and our objectives, satisfy our objectives. So the way you do this for me is when you're looking at a process or a system, you say, why are we doing this? What do we want to get out of it as a result? Then it all becomes a matter of design. So as was mentioned earlier, I had the good fortune to work on a successful online dispute resolution project called the Civil Resolution Tribunal, or the CRT. This is maybe a once-in-a-lifetime opportunity where our team was finally allowed to ask or imagine, what would this process look like if we could start over? So we took what we knew. We took knowledge, like things like only 2% of cases that are filed in courts are ever resolved in a trial. So we said, this is a great opportunity to focus on the other 98%. And maybe even beyond that, all of the cases that never get formally filed with the justice system for a variety of reasons. We had the opportunity to talk to users, talk to the public, ask them directly, how would you like to resolve your disputes? What works for you? What doesn't work for you? And again, focus on creating value with that audience or that segment in mind. A few statistics on the CRT. Well, first, the jurisdiction, they do small claims to $5,000, motor vehicle personal injury disputes to $50,000, condominium disputes, and a few other legislation-based dispute types. It does it it uses an online expert system to provide information and guidance collected directly from human experts, put into a technology to make it intelligent and provide people all sorts of support and guidance before they ever file a case, before they ever pay a fee. That system has been used over 110,000 times so far, and we're getting good results. The rest of the CRT processes, they've handled about 17,000 disputes so far. The rest of the processes involve things like online party-to-party negotiation, online facilitation, lots of case management, lots of problem solving. And if the parties can't resolve their dispute by consent, then the facilitation turns to helping parties prepare for an adjudication. So there's still an adversarial adjudication. It's still right in the main justice system. It's just that there's a lot more help for parties to get prepared. The system beautiful job at organizing that sort of thing. So what I would say is take a look if you can at the Civil Resolution Tribunal's website, go into the blog section of the website, look at some of the statistics that they collect and publish. One of the things that's really exciting they do is they ask users after they've gone through the process before they get their decision to fill out a survey. They're getting very high results. So last month in May, 96% of respondents said that the CRT was professional, 75% said it was easy to use, 96% felt that they were given enough information they needed to use the system. 98% of people said it was accessible, 92% said it was timely, 100% said that they received fair treatment. These results are from May. This is when the pandemic was in full swing. So these numbers, I would be excited about these anytime, but when this is happening in such a a difficult time for people, I think it really drives the point home. So I would just say again, don't constrain yourselves with existing processes. Think about what we can do to build new processes. I'll just finish off by saying two points that I've learned from working on different online dispute resolution processes in the public system. First, don't start off by focusing on your technology. So this applies whether you're talking about automation and digitization or transformation and innovation. Instead, focus on creating insanely good processes and then figure out how you can make that happen using technology. And sometimes you don't even need technology. I can tell right away when someone says that they want to do ODR, they're probably going to go off track because they're just going to be focusing on the technology and not the processes. Second thing is almost every obstacle is solvable. If you're creative and you're brave and you're willing to take a evidence-based and an open perspective on a lot of the problems you'll encounter, almost all of them can be solved by good design. The one thing that I found that we can't design away yet, or at least not yet, I haven't discovered how, is culture. Law and justice culture, these are the things that are most likely to cause initiatives to fail or to fail to become as good as they could. So I thought the pandemic might be the straw that breaks the camel's back in terms of culture and help us overcome some of these traditional barriers. I'm still waiting to see how that goes. Not feeling quite as encouraged as I would like, but I'm still hopeful. We've got some excellent examples out there, some things Nicole has been talking about, and Judge Mohammed certainly blazing new trails. So thanks, and I'm looking forward to the rest of the discussion.
Darren, thank you for that, and for the great detail on the CRT itself and how it works. And I will join in. I'm a big fan of the CRT, and I'll throw one more stat at this audience that Darren didn't mention, which is that when everything else in the justice system shut down, the CRT kept sailing along 100%, no disruptions, no interruptions whatsoever. So that's another, I think, major feather in its cap. I want to seize this idea of transformation, Darren, that you talk about a little bit. And at this point, I want to turn to both Judge Mohammed and to Nicole. When Darren talks about transformation, I think he's really inviting us to think in larger terms, not just about, again, how do we digitize, how do we patch up, how do we do this, remotely, but how could we approach this entirely differently, starting with the objective we want to accomplish and thinking, what are some good ways to do that? So from your perspectives, from the bench and from the first chair in the trial, what kind of transformation might you like to see, or that would you want to encourage within the trial system? I know that you would have many to choose, but if you can give us just one each to think about and to mull over, that would be, I think, really interesting. Judge Mohammed, do you want to start us off there?
Yes, Jordan, the transformation that you're seeking and what you're asking me, and what Darren has indicated, a cultural change or a traditional barriers, we have to look at it. Anytime we transform, we have to look at, the doctors look at what the focus is, a patient focused. In our system, justice system, is we have to focus on the court users. Focused on the court users. Our court users, the jurors, when they come in, I can tell you, I have presided over at least 36 homicide trials and other trials, but our jurors are so media savvy. If you flip an easel and you still take the pen and you write it, they would look at you like, what is going on? They expect us. They expect the court participant, which is the judge, the court system, physical layout of the system, to be what they consider to be, the current justice. So the transformation is going to be focused on the court users. Now, what are some of the things that I think that's going to come out? Now we're in phase 2, soon we will be in phase 3, but the system that's going to work is not what we have, a complete virtual system. Like Nicole said, there are certain things we can't still do in a virtual setting. So there would be something more or less a hybrid system, which means things that can be done. For instance, mediation. If I can do mediation, If I'm a mediator, if I can sit with two separate breakout rooms with two separate parties, bring them together, and in a fraction of a time, I can participate and I can get the results. Now, Darren's statistics are very amazing. 96% of the people that responded, that said user-friendly. So any transformation, take into account how user-friendly the system is going to be. We're not talking about digitization. We're not talking just the fact that somebody has to accept it, right? Now, one other thing that we need to look at it is how this transformation has prepared us, this pandemic. We went from, normally the process is you have a concept. As an engineer, I always look at a concept. Then you look at the concept and say, you know, we want to build something, a prototype. From the prototype, you go to a beta testing. From the beta testing, you say pilot. Well, what we have learned is we are capable, certainly. We are capable in matter of days. Forget about the beta testing. Forget about the pilot. You put your seatbelt on, you shoot, and you are in space now, and you can fly. And that's what we have done in New Jersey and most other states, because our society has geared up. We are willing to do this. And I think, like Darren said, the traditional concept now has to change. And I think transformation is the direction we're leading, but it's just that the thinking has to change. Back to you, Jordan.
Judge, thank you for that. And Nicole, from the trial lawyer's perspective, what would be your transformational idea or approach or angle that we should approach this from?
Okay, here's where I'm going to go. So there's so many things that you can do, but I think the length of time to get justice for most people, even civil litigants, is extraordinarily long for a number of different reasons, particularly if you are putting on witnesses live and you have a jury trial. That is not something that you can do endlessly, 12 hours at a time. And I think the same holds true. Actually, I don't know how many people are getting Zoom fatigue, but if you've been on a number of Zoom calls or video calls, after a while, you're exhausted. And I don't know that a virtual jury can be as attentive as you would want them to be hours on end. So what about the idea that if there is going to be a trial, that things like the opening statements are recorded in advance so that they're actually polished and they're ready to go, that you may take witnesses live on video with the judge or perhaps in the courtroom without the jury there, but that the objections get ruled on or the sidebars get ruled on, and then it's compiled into an edited version that the jury is then watching without all of the interruptions that come in a normal trial day. Things of that nature. I think, you know, in the end, the ability to pull up exhibits in the same way as if you were in a courtroom or live with everybody is going to change drastically. And while I know you can get adept to it, I've done a lot of trials with, you know, the exhibits that you can actually just pull up and mark on the board. But there is a fair amount of, you have to get adept to it. And I think after a while, people are going to want to try to simplify what they're presenting. So my feeling is the one thing that you could do is reduce a fair amount of time in the resolution of evidentiary hearings or the resolution of presenting a jury trial. You know, I've done a 6-week trial, and if that could have been, you know, split in half, that would have been remarkable and far less costly.
Nicole, thank you for that. And it gives me a chance to say to the attendees generally, I'm going to try to set aside 5 or 10 minutes at the end for questions. I've gotten one really good one already. If you have a question you'd like to pose to any of the panelists, enter it into the chat bar. Just click the chat icon at the bottom of your screen. It'll bring chat up, and then just type it out, and we will monitor it and ask it around. So let's get kind of practical at this stage. I'm interested in this, and Darren, I want to bring you into this part of the conversation as well. But again, for Judge Mohammed and for Nicole, what are your practical suggestions or tips that you can give to anybody who's involved in this process? You have been through a number of these, as you say, trials already. Many people have not. They've only had a couple or maybe none whatsoever. From your perspectives, what would you like to see? You know, Judge Mohammed, what do you want to see lawyers and witnesses do? Nicole, what would you like to see judges and court staff do? And then Darren, I'm going to swing around to you directly after that, just to give us some of your thoughts about design, how we can apply design thinking to these questions as well. But Judge, why don't you start us off with this?
Well, a few things, the best practices that I usually teach our lawyers, judges, and everyone. And the first and foremost is make sure you test your devices out, which means, 10 minutes planning, 10 minutes, 15 minutes before the start of the session, turn your computer on, turn your camera on, and, have some of these things. And technology is going to fail. Be ready for a technology to be failed. So what I do in my courtroom is if somebody is speaking, let's say there is a poor Wi-Fi, and I want to be able to communicate, but their audio or video is on, but audio, I simply do this, poor Wi-Fi. And if I have something I cannot hear, I can simply do this. I hold this thing in my hand, right? If somebody says they are going to, the interpreter says, I cannot keep up with them, I just say, counsel, slower, counsel, louder, right? You can have this one. At home, my wife is a physician, and so we have a hospital in home, we have a court in our home, and we also have a university because 2 of my kids are in college. We're all doing the same thing. So what I do is when I'm on the bench, when I have a court session, I have one of these. So the triangle that I have, it simply stays there. So which means no running in, daddy, can I do this? No, you do this one. And I use the same thing in court. Now I have this one, I tell counsel, if this flips, you mean the interpreter is exhausted. You need to slow down, right? So all of these things help. Now I have another device that I call Gizmos and Gadgets. That's my title of my program that I give to judges. I always have a backup jetpack. Verizon has a jetpack. This is an internet lifesaver, which means if my Wi-Fi goes down because my son is playing this game upstairs, 2 of them are playing video games, I want to have this backup so that it doesn't, knock me out. So those are few things. Now, in terms of judges, it's very important for counsel to let the judge know. Judge, when I come in on a Zoom session, law clerk, I would be looking at this because I have not met my client. I would like to speak with my client. So if there is a breakout session or a room that's available, can I do that one first thing in the morning when I come in? Because some judges may not know there is a breakout option that's available. So it's good to know, right? And also good to prepare. If you have an interpreter case, let them know, Judge, we're going to be needing an interpreter because, again, connecting remotely interpreters in the language that you want, that requires preparation. Now, I have few other items that I have, and that is, now, your background. Make sure your virtual background, I'm just going to show you a very quick one to show you how quickly you can turn your background. And it's important for us to have, here I am, I'm in my courtroom now. Right? I'm right there. I'm in my courtroom. But what I do not want counsels to come in is to come in with a background that is something very distracting and something that will simply give me jitters, because you don't want to have. The other day, one counsel came in and the background was a baseball game, live baseball game that was on the background screen. I said, counsel, this is not a ball game. This is a court. So I reminded him to change the virtual background. So that can be done. And a simple thing is, right now I'm in my basement. All you see, if you're giving a presentation on a Zoom or other virtual courtroom, have a background that is very simple, because nobody wants to look at the bricks behind me. So they are really focused on the presenter. They're focused on me, right? Correct? So now few other items that I have. Exhibits, I require counsel to submit all exhibits in a PDF format 5 days in advance of the hearing. And the reason it's important is not only we want to have an electronic version so that everyone has it, and like Nicole suggested, my normal practice is 2 days prior to the hearing, all evidentiary issues that can be resolved, we try to resolve them. Any stipulations, we encourage stipulation, authentication, all of those issues are resolved. So on the day of the hearing, we can proceed. Now, one additional item is I just completed 2 competency hearing this week. These are 2 individuals. One individual was doing so well, regained competency, and this individual now is ready to stand for a trial. And that case should not have to wait 3 months for us to bring a person from a hospital 100 miles away to a courtroom. I did that one yesterday, and we're going to have a trial date soon. Now, justice does not end because of pandemic. justice is something it's more important in a situation such as this. The other person was a person whose competency was issued, and that person is going to moving into a new cottage with passage, family visit. So it's critical that we address these issues with the formalities that we have, and always have a backup plan. And the backup plan being, if your internet goes down, you have this device. If your laptop doesn't function, you have another laptop, because the last thing you want to do is come to court and get out because of the technology and you can't get back in. And that's pretty much it. But I would suggest the things that they can prepare.
Judge Mohammed, not only are those great tips and tricks, but as the father of an inveterate 13-year-old Minecrafter, I will tell you I am grabbing one of those lights and I'm going to use them, because that is right up my alley, I'll tell you. That was great. Nicole, what are some of your tips and advice and tricks and so forth?
Yeah, well, first of all, Judge, I wish that your temperament and what you're doing was the same across, you know, all of the judiciary, because it's really fantastic. And I think it invites litigants to feel comfortable that we know that the person that we're presenting our client's case to is adept at all of these. So great for you. And let's go in on a business together where we manufacture those cards, because I'll tell you that I would love a set of those right now. And I think a lot of people would, so we could talk offline. But for me as a litigant, you know, I happen to think that if this does go on, there's going to be this whole new crop of consultants that comes to light. And it's, instead of jury consultants, it's going to be kind of online presentation consultants for court purposes, right? Because there's so much that you really need to think about to polish and to get right. So for example, there are legions of stories of people who, you know, are showing up for court, you know, dressed in, like, you know, basically their pajamas or things that you would ordinarily never step foot in a courtroom in that way. I have noticed with a lot of my colleagues that, you know, when you have multiple screens, as a lot of people do, I do as well, if you forget and you move, you know, whatever you're looking at over to the screen that doesn't have your camera, you end up talking like this. It's very disconcerting when you're not looking at the camera. So these little things, just a best practices of all of the things that the judge just mentioned, I think will be very, very important. From my perspective, Jordan, you asked what my experience was so far. I will tell you that, you know, I should have had probably 5, 6 online hearings that have been scheduled, and almost all of them have been canceled. And I think partly it might be because they weren't necessary and the judges are really looking at their schedules, they're backed up. But I also think that not all judges feel comfortable with this process. And as a result, they're kicking it thinking we'll go back to this, you know, to the old way when things start to open up. And that's concerning to me because it's delaying my ability to move the case forward. So my hope is that judges, you know, I think you should put on a seminar, Judge, for all judges to really become more adept at this and to welcome this, because I think it will be fantastic for litigants, fantastic for clients. Yeah.
I really think that's right, you know, and like I said before, the more you experience it, even just the one time, as a judge, as a litigator, as somebody who's involved in the court process, it just demystifies it, you know, and it starts normalizing. And we need that. We don't need a new normal. We need a new normalization, I guess, in a lot of ways, just to let people have the chance to get in there. Darren, I want to bring you into this because when we talk about practical tips and approaches and so forth, you've made some really good points, I think, about rethinking some aspects of the justice system. If someone were to say to you, okay, listen, that's great, I love the idea, but where do I start? Give me 1 or 2 practical areas where I can actually get started on this process that will get me pointed in the right direction.
Well, I think I would probably join in Nicole in figuring out a way to clone Judge Mohammed and hire him in every court I can. That would help a lot, I think. But when I hear when he was describing about the ways to, you know, bypass pilot projects and beta testing, I'm hearing like just do it. And I think a big part of that mindset for me, the part I identify with, is this idea that perfection is the enemy of the good. And we need good right now. So let's start. Just do it, and you can change things on the fly. You can make improvements as you go. The psychology is, I think it's key to building what I call a continuous improvement culture. So this is a system that doesn't fail over time. It is a system that gets better over time. The more people who use it, the better it gets. Bringing that back in into the realm of design thinking and user-centered design, it's about talking to people. So, and by the way, you don't have to bring in a bunch of high-powered user experience design consultants to do this. You can do it with a clipboard. You can do it with SurveyMonkey. There's nothing easier than SurveyMonkey these days. Send a survey out to your users before they engage with your system. Send them a survey while they're engaged with your system. Send them one when they've finished engaging with your system. You'll learn a lot. You can collect a lot of valuable data. You can look for pain points. You can watch for trends up or down in certain areas. But again, you can also use this to inform your continuous improvement culture. So if you're seeing a trend, identifying some sort of problem in some area, make the change, then watch the data for your next quarter. See if you've actually made an improvement. And again, over time, you'll create a system that gets better and better the more it gets used. Last thing I'll say about designing these systems is, the rule I like to follow is the moment someone says you need an instruction manual, you need to go back and start over. So if you're designing a justice process that can be just picked up, like within reason, more or less, people could just pick it up and use it without having to read a long set of instructions, then you are winning. You can do things as well, like take your rules of procedure, build it into the software and the system so that it just becomes instructions. It guides you all the way through. If you do this, change management will be a breeze because everybody will be able to just pick it up and use it. And I'm not just talking about self-represented litigants. I'm talking about staff. I'm talking about judges, and I'm talking about lawyers. That'll also be a good way to keep yourself honest in terms of not falling into the feature creep problem where you add feature after feature after feature so that the system can do absolutely everything. Unfortunately, though, nobody can understand how to use it. So these are some of the ideas that I definitely would like to sort of push in terms of design.
Darren, thank you for that. And I especially want to say that your observations about surveying people before, during, and after, I want to say to all the lawyers here today, that applies 100% to your clients. You know, what Darren's described here about the design process applies to the client experience, I think, just as well. We've got time for some questions. We've had some really good ones in the chat. And I want to start by posing this one to just all of our panelists, so feel free to pop in wherever you like. And I want to take two questions and combine them into one. Because one question was, okay, how do we incentivize? How do we encourage people to engage with this with this new system and this new approach? How do we kind of overcome those cultural barriers? And then the flip side of that question is, what about barriers, especially regulatory barriers or issues that, is there some reason where like a state bar or a Supreme Court or someone's going to say, no, you can't do that for whatever reason? So we're talking both incentives and disincentives. Open the floor to the panel. Who'd like to comment on either of those?
Jordan, if I can just jump in with regard to the barriers, I think this is a beautiful example, like Darren indicated. You know, just do it. What the Supreme Court have done throughout the United States and throughout the world is they have taken the position. For instance, when a signature was required, I just did a search warrant. And normally a detective would have come in and the assistant prosecutor would call me and we would go through, I would review the search warrant and then I will have any questions and then I will sign off on it and I will release it. Well, this was all done electronically, which means a portal is set up. I reviewed all the documents. Now, the beauty of this concept is, number one, it requires a certification, a signature that the detective has signed. Our Supreme Court now allows a certification instead of a signature. Now, that is tremendous. So if that can be used in a non-pandemic situation, that eliminates a lot of the processes that need to be. Why does somebody have to come in if that person's job and an assistant prosecutor is on the line? So that's one barrier. Our court rules are, I think I will see, I'm projecting that, or they will be more receptive to make changes and these kind of changes. And the other issue is with regard to the first question that you had, Jordan, what was the first question?
Oh yeah, about incentives. How do we incentivize? How do we encourage?
Greatest incentive that I always start with when I give my presentation, and Nicole, you're right, the judges, I just did a seminar for judges, evidentiary issues in a virtual setting. 300 of our judges attended, including appellate judges and stuff. And it is yeah, you're right, absolutely. The judges should know about this. The judges should be trained. Once they're comfortable, they would have this message out there saying, we are receptive litigants, our attorneys. So one important thing that you can have receptiveness is bring along the attorneys, which means training the attorneys, judges to be involved in training attorneys, because these are the court users. That sends a message to the attorneys. We are welcoming you into this new technology. We are there to assist you in the sense that we want you to be a court user. So that receptiveness should come from our side, from the judiciary side, be more welcoming, to work closely with the Bar Association and others. So I think those are the two responses that I can provide. Back
awesome,
to you.
Thank you. Nicole, thoughts on incentives and disincentives?
Yeah, well, I'm a huge believer that if the court is mandating using online processes to adjudicate, matters, that's the incentive, right? You very quickly, if a judge tells you that you have to, do X, Y, or Z, typically the litigators are going to have to do that, and the clients will come along. And so I think that's the first way that you do it, is making sure that the courts are providing the training that Judge Mohammed talked about and providing the resources as necessary. I think we'll get to a question hopefully about access to justice and what do you do about people who don't have the right broadband or technology. And I think that's absolutely has to be addressed. But assuming that the courts are facilitating that, or others who are friends of the courts are doing that, then I think the courts should mandate it, and then people will very quickly come along. In terms of the disincentives, I'm really hoping from a regulatory standpoint that actually, if we went to this more as the mainstream, that some of the regulatory obstacles just to practicing law are going to fall by the wayside. So for example, in certain jurisdictions, particularly state courts, the requirement to have local counsel, when, in reality, in today's world, anybody who's licensed in one state knows how to research the law of another state. There may be some procedural rules that you need somebody who's local to weigh in on, but to have them appear at every court appearance, as some jurisdictions require, to me is a waste of money. It's just unnecessary at this point. And I think as that happens, also some of the rules about being admitted into a jurisdiction, not just pro hoc, but in order to represent a client in one place, if you're not actually admitted, there are rules against that. I'm hoping that in this day and age, those type of things are going to fall by the wayside, and the focus is really going to be on access to justice. So perhaps a lawyer in Montana who's equally capable of handling a matter right in New York City for somebody could do that online in a way that just would never have been appropriate or the way to go in the past. So my hope is that the regulations and the obstacles diminish as a result of this.
Those are great examples, Nicole. And I love the point about the Montana lawyer in New York. I mean, talk about barriers, unnecessary barriers that have a negative impact on access. And to speak to the access point, and thank you, Nicole, for flagging it, because it was a really good point that's been made in the chat. And I want to ask all three of you about this. And Darren, I want to start with you, especially because of your experience in the online format. But not everybody has broadband access to the internet. And not everybody who has access to the internet can do so from an environment that is stable, or that is appropriate, or that is safe, quite frankly. And, you know, and this is not the justice system's fault, obviously, but how can we start making some adjustments now to how we approach this? What are some potential solutions to the problem that the accessing this entire process online is not a universal benefit at this point?
Yeah, so we in online dispute resolution circles, we call this the digital divide. Quite often, it's people who are either unwilling or unable to access technology. So yeah, we definitely don't want to create a new barrier for accessing justice. As I said earlier, aside from culture, I've never met a challenge that couldn't be dealt with by design, and so that is true for the digital divide as well. So it's actually quite easy in my experience to just use mixed channels. So you set up your system so that it can work across multiple channels. It can work across a web portal. It can work across email. It can work across telephone. It can allow for in-person. We can even set these things up to work on fax machines. And so once you work across multiple channels, it really does, it doesn't completely solve the digital divide problem, but it can go a long way. Also, if you set up your system so that things are happening remotely and asynchronously, then you will greatly expand the potential for people to get help from lawyers, paralegals, different types of advocates, family members, trusted friends. If they can do things, take steps on their own time in their own place, then it really does allow them to overcome a lot of these problems. And that could even be the person at the far end of the age scale. So someone advanced in age who is English as a second language, they can sit down with their adult child and they can get the help they need to interact with the system. So as I said, a lot of these things can be dealt with by way of design.
Fantastic. We've got 2 minutes left, so before we have to wrap up, Nicole, Judge Mohammed, you want to give some final thoughts on this issue of access?
Yes, one thing that I'm thinking about is I'm sitting here, Darren, saying that about the digital divide. Yes, maybe somebody like Elon Musk, who has already installed all these satellites, 500 satellites. Now, a concept of a toll-free, just like a toll-free number that you have, a toll-free type of a Wi-Fi that people can simply tap in locally, it's available. So that's something that can be done. I mean, it's a good concept, it can be done. The other issue is, we talked about in New Jersey, that courts are going to be providing laptops or tablets for court users who want to use it. They can come in, they can borrow. If they're remotely going to be on a jury trial, we would allow them to have this one. So courts have to make those accommodations. And lastly, the judges have to be very, very receptive in the sense that if somebody needs help, to take the elevator, this is not an ADA issue, but if somebody needs help, technology help, why not provide that help to that individual? Somebody needs help to log in. What is there for a court other than it facilitates and it promotes access to the courts?
Brilliant. Nicole, you're our closer at the 9th inning. Let's wrap it up for us.
Okay, I'm just going to say that, there's going to be a lot of WeWorks and other places like that probably aren't going to be used too much. Let's use some of them. Let's fit them with, the technology needed so that there's a place that people can go to if they're not going to be able to use their homes, put them in communities. I also love Netflix. So why can't we have, laptops or things that are being sent to people who need it, and then they have to return it within a certain amount of time. I think there's a lot of creative ideas that we can come up with, but it's imperative that we do that because we can't allow expensive technology to create a greater divide to the justice system.
Nicole, Darren, Judge Mohammed, thank you so much for your insights today. Michael Mills, back to you.
Simply to thank all of you who are attending and thank all of our panelists, and thank you, Jordan, particularly for moderating. We will post this as a recording, and We did circulate in advance a reading list with some suggestions from the panelists. I'm sure all of you did your homework well in advance of this morning's presentation. There are a number of very good pieces about the work of some of the panelists and about others in the field who are tackling these issues. So we invite you to have a look at those, and thank you until the next college conference. Thank you.
Everybody. Take care.
Thanks,
Bye-bye.
everybody.
Be well.